Good morning, everyone, and welcome to SharedHR's 2015 HR Compliance Update webinar. My name is Ashley Clevenger, and for those of you who are not familiar with GoToWebinar, I'm going to give you a brief overview. Firstly, you should notice a GoToWebinar taskbar on your main monitor screen. It should be noted that only the panelists, Paul, Saul, Bruce, Amy, and myself, have audio capabilities and control. The rest of the audience will be muted for the duration of the webinar. Should you have any questions during the presentation, please use the question chat pane located on your GoToWebinar taskbar. We will field several of the questions during the presentation, and the remainder of the questions we will follow up with afterwards. You should also use this question chat pane if you begin to experience any technical difficulties. We will try our best to assist you with any issues. Furthermore, we will be recording this webinar. For those of you who are interested in obtaining a copy of this presentation afterwards, please contact our offices. Our firm's contact information, as well as Paul, Saul, and Bruce's, will be provided at the completion of the presentation. I believe that is all for now. I'm going to pass it over to Amy Kellerman, who will be introducing our speakers.
Hi, thank you, Ashley. My name's Amy Kellerman, and welcome everyone. I'm the Director of Professional Services and a Senior Consultant here at SharedHR. So I'd like to thank everyone for joining us this morning. Our first presenter will be Paul Finkel, who's President and CEO of SharedHR. Over the last 30 years, Paul has worked with hundreds of organizations as a senior advisor on HR and business strategy, risk management, and compensation. Paul is regularly called on to be an expert witness in complex employment litigation, and with SharedHR has developed a proprietary HR compliance and technology system. Next, we'll hear from Saul Macias. Saul is Vice President of Professional Services for SharedHR and has over 20 years of experience in human resources, working with nonprofits and for-profit businesses on organizational development and design, performance management, and HR technology. Saul is past chair of the Board of Directors of the Northern California Human Resources Association. And our special guest today is Bruce Jobson, Director of the Human Resources Group for Keating Consulting's HR practice. Keating Consulting is a Silicon Valley and San Francisco-based accounting firm and consulting group which provides interim and startup financial leadership to organizations in the Bay Area. Bruce regularly works with small to mid-sized businesses to maximize organizational and financial results by aligning HR strategy, leadership, talent, and processes. So our agenda today covers a variety of hot topics in compliance: California sick leave, EEO and harassment, employee benefits and the Affordable Care Act, new protections regarding discrimination, some new guidance on smoking and cell phones, and the latest on NLRB rules that non-union as well as union employers need to be aware of. And so with that, we will start it off with Paul Finkel.
Thank you, Amy, and good morning, everyone. Well, it goes without saying that HR compliance isn't getting any easier for employers. You have federal requirements, state requirements, municipal requirements. You have to monitor court decisions, regulatory agency rules. There's just a plethora of information that one has to monitor to stay on top of this compliance. And people do it in a variety of ways. They look at the legal advance sheets, they go to webinars and seminars, but the real trick is how do you take all this information, synthesize it down to what's really important, and then what do I have to do in terms of either changing a document, such as an employee handbook, or a practice that your managers and supervisors may be executing. So we have been developing at SharedHR a compliance model for over 30 years, and we make on average 15 to 25 changes to our model employee handbook platform a year. And what we've done for 2015 is sort of boiled down the highlights that we're going to talk about today so that we can give you an idea of what's really important and then what kinds of changes to either your practices, because some of them have to do with healthcare and benefit practices, and actually your employee handbook and hiring documents. So first, if we can go back just one slide, please, Ashley. In 2014, it was a busy year for legislation in Sacramento. We had more employment related legislation in California than we have in the past 5 years. Part of it was an improving economy, so all the boats are floating a little higher when the tide comes in, but also it was the fact that we have a democratically controlled legislature as well as Democratic governor. Not that he signed every bill they sent him, but he did sign a lot of them. And you have the general perception of the legislature here in California that they're supposed to legislate employment legislation. So we have a bill, for example, that doesn't require necessarily a change to the handbook, but is a bit of a highlight that we wanted to call out to you, this 1897, which is essentially a bill that says if you use any kind of labor contractors in California, that's either a group of independent contractors or a staffing firm, you as the engaging entity now have to be aware that California law requires you to look into the practices of that entity you're engaging. Make sure they have workers' compensation insurance, for example. Make sure they're paying wage and hour correctly. And if you fail to do that, then you will end up being liable for that labor contractor's failure to do so. Now, in California, we locally, we have ordinance after ordinance being legislated by various municipal entities, and we just called out a few of them here. But you've got to devise a way to track where your employees are working by municipal entity and what laws cover them in the HR arena. So we have Oakland sick leave going into effect this week, which is a sick leave ordinance I'll touch upon in a moment. And then San Francisco has sort of a lesser-known retail workers' bill of rights that impact the retail industry of all types in San Francisco. Not to mention things like the San Francisco City 1% payroll tax. So if your employees are working in these municipal areas, you've got to have a strategy for staying on top of this compliance. So the next slide, I want to look at basically why should one worry about HR compliance? What's all the fuss about? Well, the real issue, and this is conversations we have in our firm with out-of-state employers, is that we have this interesting law here in California known as the bounty hunter law. And it was very big news a few years ago, and it's kind of been quiet now unless you are involved in this type of litigation. And essentially it goes like this. If a plaintiff's attorney can find a technical violation, such as bad handbook language, then they know under California statute they're going to be in the money. They're going to have their legal fees paid by the employer. So the next step for them is to try and find out if it's a class action lawsuit. So for example, if you have the wrong information on an employee's paycheck in California and you send out paychecks to all employees with this incorrect information, that is a technical violation and the subject of a class action lawsuit. So this HR compliance is a rather broad term, but the teeth in it really is in California, which is unlike other states. Individual lawyers can take on these cases. In other states, you typically have to go to an agency as an employee or even a class of employees to file your complaint. In California, all you have to do is find an interested plaintiff's attorney. The other issue is that employees are well informed on their employment rights. I mean, there are solicitations by attorneys saying, gee, do you think you've been wronged in your workplace? You can hear them on the radio on Sunday mornings. And just in general, with the amount of information available on the web, people basically know their rights at work. And the issue with this for employers are that if you're interested in your culture, you don't want to be an employer that's perceived as not caring about HR, because those best employees, those top talented employees that you want to attract and retain can vote with their feet. And believe me, there's a lot of recruiters. The recruiters that we work with are as busy as they've been in the last 5 to 7 years right now. And that means they're probably contacting your talented workers. So let's talk about the first bit of compliance now on California sick leave. The California sick leave ordinance is probably the best known of the 2015 new compliance challenges that employers have. So if we could go to the next slide. It's really generated from this piece of legislation called AB 1522, the Healthy Workplaces, Healthy Families Act of 2014. And it doesn't come into effect until July 1, but you need to start preparing for it now, and you need to have your posting up now. And basically, it covers any employee working in California for 30 days or more. So that's a rather broad net for tracking eligibility for sick leave. And essentially, employers must accrue 1 hour for every 30 hours worked, up to 48 hours or 6 days. And there is an option, and that other option is that you can just grant everyone 24 hours or 3 days with your total cap of 6 days or 48 hours. And as we'll talk about throughout this presentation, the way these agencies, such as the Department of Fair Employment and Housing, and the courts in California look at this, is that the most liberal interpretation in favor of the employee is the one that the employer should go with. And we'll talk a little more about that later. But essentially, from an employer's standpoint, and this is particularly challenging for smaller employers, you have to be able to track hours of all your workers. And you have to be able to track them and report on them for these types of accruals. And many employers are still using paper or spreadsheets, and it's really hard to do that with a spreadsheet. The other challenge is that you have to track these accruals. So, if you're going to keep it as sick leave, which most of us know that in California is not required to be cashed out when someone leaves, then you have to track this sort of rolling accrual model that's required under AB 1522. Now, if you provide PTO, paid time off benefits, which combines vacation and sick, then that PTO can count and cover your sick leave requirement in California. The downside of that is, as soon as you turn sick leave into PTO, now it must be cashed out upon termination. So that's a reason why employers don't want to do that sometimes. But sick leave and PTO, in both cases, you've got to have this sort of rolling accrual. The Labor Code also has been amended by 1522 to require notices, which you should already have posted about this new sick leave. And then this record keeping I've been talking about, you can be, if someone raises a claim that they weren't entitled to sick leave, then you've got to be able to show that. Similarly, in San Francisco and in Oakland, you have slightly different ordinances now that you must harmonize if you have workers in these areas. And the scope of today's presentation, we can't get into all the flavors of this, but you must be aware of these ordinances. And we'll talk about some of the war stories we've had where our clients, were not aware of some of these ordinances, or people working with them were not, and rather steep penalties are associated with it. So next, we have a participant polling question for you. And Amy, would you like to handle this?
You bet. So we're going to do a few polls today during our webinar, and Ashley's going to launch that poll so everyone can vote on this question. It is, I'm confident that we have the tracking systems in place to administer the new California sick leave. And while you vote, I think we're going to take a question, Paul, about the California sick leave. If I have an employee who works part-time, 6 hours per day, can they be limited to taking 18 hours per year of sick time? That's 3 days based on their part-time schedule.
Yes, so actually the Department of Labor Standards Enforcement has given some guidance on this. So the short answer to that question is no. You know, as I was alluding to earlier, the way California looks at this is it's, you know, whatever's higher, the employer has to follow. So if we're saying 3 days or 24 hours, and then, you know, 3 days would normally be 6 hours, 18 would be something like 18 hours, you would have to give the person up to the 24 hours. So similarly, if a person's working a 4-10 work schedule, for example, they'd be allowed the 3 days, which in that case would be 30 hours. So there's actually some links on this and some FAQs that the government has put out on this through the Department of Labor Standards Enforcement. And we can provide those links to anyone who wants to contact us later on these kinds of questions. But this is typical of you name the law and regulation. You know, if there's a way of interpreting it more favorably for the employee, that's pretty much the way California does it.
Yeah, hello, Amy, and hello to our audience. I think that's just one more reason why everyone should be looking at their sick pay accrual policies right now and just get ready for it, because there's so many variations, especially if you have flexibility in the schedules that you permit, to ensure that the accruals map to what the new standard is going to be as of July 1st.
Absolutely, that's a great point. So Ashley, and thank you guys for the answers. Ashley, maybe we can see the results of our poll. So 48% feel like they are ready with tracking systems to administer the California sick leave. Panelists, what do we think about that?
Well, that's good. But for all those that answered no, you know, you've got from now until July 1, so this should be sort of your wake-up call. And we're going to talk about this more, but we are familiar with and work with a lot of payroll, time and attendance, and HRIS systems. And even as a small employer, this is really going to confound you, this sick leave thing, if you don't have a technology system helping you track all this. Because the reporting, you know, even through a regular payroll system is going to be challenging. So this should be a wake-up call to get cracking on how you're going to track this.
I think that's a great point. So next then we're going to introduce Bruce Jobson, who will be talking with us about equal employment opportunity and harassment. Bruce?
Thank you, Amy. Hello, everybody. When discussing harassment in the workplace and the liability that it carries, it's important to understand the framework of protected classes. And you'll note that there are both federal and state equal opportunity laws. Not surprisingly, as most of you are probably aware, the state of California often sets statutes that go above and beyond the federal government. And this holds true in terms of equal opportunity in the state as well. As you can see, the second paragraph, which is the California version, if you could go to the next slide, please, Ashley. Thank you. Yep, the second paragraph is the California version, which is broader and more encompassing definition of harassment. And as a result, it's really important for California employers to keep this aspect in mind. Next slide, please. When it comes to harassment, the employer is responsible for the acts of its supervisors. And yes, believe it or not, off-the-clock behavior counts. I'm sure that Paul or Sel could certainly talk to this aspect, because as an HR professional, I can tell you that a fairly large majority of harassment claims happen during non-business hours, and believe it or not, usually involve alcohol as well.
Yes, unfortunately it does.
All employers are encouraged to prevent and address any claim of harassment, and risk really comes into play if there is a tangible employment action that could be tied to the harassing act. As a result, employers should have a framework established in their workplace to prevent and address any behavior that's considered harassing. Further, it's really important for the employer to understand, the employee, excuse me, to understand that framework as well. Next slide, please.
One point on that, Bruce, if I could, and that is that we have a case going right now where an individual was not given an annual increase, and the individual waited until that tangible employment action occurred, seemingly innocuous, because this person wasn't the only one who didn't get a raise, and then filed her complaint of harassment and discrimination. So that is a sign that the employee is getting coached, because they know they waited to file the complaint until there was a tangible employment action. And this is very common out there. I mean, employees, many of the complaints we deal with are by sophisticated, increasingly sophisticated complainants, and they're getting coached by their plaintiff's attorneys.
Yeah, well said. It's it's really important, back to the whole, as it relates to the having that framework around being able to address that and notice the signs, as Paul said, to be able to swiftly and actively deal with the claim once it's brought to your attention. So next slide, please, Eckler. So one of the things that I think it's important to note is, in terms of best practices, a good harassment policy is really one of the best places to start. Within the policy, having a clearly defined complaint procedure lets your employees know how to notify the company. That's very important. And on the last slide, you may have noticed the term affirmative defense. And really what that affirmative defense is, it has to do with the employer being encouraged to prevent and address any claim of harassment, and having a framework in place to prevent that type of behavior. And a harassment policy is really one of the best places to start. And within that policy, it's also very important to have a clearly defined complaint procedure to let your employees know how to notify the employee and what that process looks like. Oftentimes, it's, particularly with smaller employers, an employee doesn't necessarily know where to go if they experience some type of behavior. And having that articulated in a form of a handbook and communicating that through trainings with the employees is very, very important to that affirmative defense that I mentioned earlier. If a complaint is raised, it's also really important to have or to conduct an effective investigation. And having that investigation conducted by somebody who is experienced in conducting that investigation, but also can advise you as it relates to ways to mitigate the risk. So, for example, if a female complains about a male harassing her that happens to be the supervisor, it's really important that maybe to have that individual maybe report to somebody else until the complaint can be straightened out and investigated properly. One of the things that is noteworthy on the communication and prevention side of things, having some training framework around communicating the process to the employees is important, but also you want to make sure that your supervisors are aware of how to handle complaints, and certainly the rules of the road of what's considered acceptable and not acceptable behavior. And in California, there's a law that's out there that's called AB 1825, and that actually requires sexual harassment training for supervisors for firms that have 50 or more employees. And for those of you who have employees or in multiple states, if you have a supervisor that is in another state, that supervisor is actually going to be required to take that training as well, because they're supervising somebody in the state of California. So it's really important to make sure that, back to the, similar to the sick leave discussion we were having earlier, you want to be able to have a mechanism around, if you're conducting training, who's been trained, when they've been trained, so you have that as a record. You know, even if you're not at that 50 person mark, I do recommend to my clients to have some form of training, not just for the supervisors but for all employees, because that also goes back to the heart of the affirmative defense as well.
And Bruce, I just want to illustrate one example here and kind of underscore the importance of training everyone in the organization. We had a client once that had a very diligent practice of training employees in harassment prevention, but for some reason the executive team were exempt year after year of providing this training. Well, lo and behold, in one of these off-hours events, we had a situation where an executive actually did not conduct himself accordingly. And now the organization had no affirmative defense there because they had records of everyone taking the training except for the senior leaders, and this, of course, would put the client in hot water. So as an internal HR director, we have a lot of participants on this call. If you are one of those internal HR folks that are providing this training and you're having trouble getting your senior executives to comply, or somehow they get a pass, reach out for help. Sometimes it takes an outside person to come in and explain to them the critical nature of this training to help you.
Yes, and if you don't have an affirmative defense, that means in California you're guilty, and it's just how much. So it's kind of important to have the affirmative defense.
Yeah, that's a great point, Paul. Thanks everybody, and Bruce. So next we are going to hear about employee benefits and the Affordable Care Act with Paul.
Great. Well, as everyone knows, the ACA is extremely complicated, and we're certainly not going to do it justice in this compliance overview. But there are a couple of highlights that I wanted to bring out to you. The first one, which is sort of an overview, is if you're not partnering with your employee benefits broker on ACA compliance, or let me put it another way, if your broker isn't partnering with you, then you should either A, ask for it, or B, think about getting another broker who will, because that distinguishes, in our view, good brokers from not so good brokers. It is a complicated area, and there are a lot of unique practices, some of which we'll touch on today, that were fine prior to the ACA that seemingly ought to be fine, but they aren't anymore. So let's first talk about the reporting requirements, because that's the big deal that's coming up right now. And that is an applicable large employer under the ACA is defined as 50 full-time equivalents. That doesn't necessarily mean 50 full-time employees. That means FTE. So that means that you have to do the calculus. You got to look at part-timers as well, and if those hours add up to 50 FTEs, then you're covered as an applicable large employer. And by that, we're talking about 2014 employment now. So you can just take a quick scan of your W-2s, and if you've got 50 or more of them, you better be very sure, if you're trying to get underneath the wire, that they don't turn into FTEs. Secondly, fully insured employers, month-by-month reporting is required. So that means that you've got to be able to show how many part-time and how many full-time employees you've had month by month, and be able to show whether they earned coverage or did not earn coverage. The reporting documents now for these large employers for 2015 are the documents highlighted, and there's a lot of information about what needs to go on them. So we're kind of coming back to the recurring theme once again of tracking. This is why I made the point earlier. If you're not able to track hours, you've got the ACA, you've got new sick leave ordinances, you have minimum wage ordinances, you got a lot of things that all relate to hours, and you need to be able to track and report on those. The big other point I wanted to raise, and this is one of those kind of sleeper ones, are cafeteria-style plans. So many of our clients used to have a program years ago, and have had, and still have it now, where they said, you know what, we may not want to have a group plan, so what we're going to do, we're small, we're under 50, so we're just going to give everybody $500, $750 a month, and go forth and use that to pay dependent coverage on your spouse's plan, buy your own plan, whatever, but it's supposed to be used for health insurance. Well, that type of, sometimes known as cafeteria plans, are no longer legal under the ACA because it's considered to be a dollar limit plan. Now, the IRS only late last month gave an extension on those plans for 2015 to small employers. But we're still finding many of our clients have these kinds of plans in place, and you need to connect up with a benefits professional. Sometimes small employers go directly to Kaiser, or they go directly to Blue Cross, and there's no broker in there, and there's no one to tell them that these kinds of plans, are not legal anymore. So that's why we decided to highlight it in this presentation. The other thing that's happening is, there's a definition now of part-time versus full-time. So full-time is 30 hours or 130 hours a month now. So we have had some employers that had 32 hours, for example, and still called that part-time because it was less than 40. And we're now changing the handbook language to basically comport with the new ACA definition of part-time and full-time. And I would strongly suggest you take a look at your definitions of part-time and full-time and temporary to make sure that you're not permitting longer levels of employment and then not counting them as covered under the ACA. Also, we've had a number of clients in the last year run afoul of San Francisco's benefit ordinance. And so, again, you have to kind of have this regional overlay. So when you're looking at your policies, kind of take a look at, okay, what regions are my employees working in? San Francisco, for example, technically views it as though there is some sort of a giant umbrella over the city, and that whenever a worker comes under that umbrella for even an hour, that counts as an hour's worked in the city and county of San Francisco. Now, tracking that is a nightmare for lots of employers, but I only raise that point to say that if there's ever an audit and they can prove that you had employees working for an extended period of time in San Francisco, even if you don't have an office there. I mean, this happens in the transportation industry, for example, where a driver's primary route are deliveries in the city and county of San Francisco, that you may well and probably are covered by the city ordinances. So you have to make sure that you're compliant with them. So again, I'll just close this ACA section by saying you should really be partnering with your benefits broker, making sure the kinds of plans you're offering are ACA compliant and that they cover you for the various city ordinances which may apply to your workforce.
Yeah, and just as a shameless plug for SharedHR, we have the privilege of being able to work with a number of brokers out there. So we kind of have some ideas. If you're wondering whether your broker is providing you with adequate service and guidance on these very complex issues, give us a call.
Yeah, we'll be happy to give you a couple of names of highly competent brokers out there. Yeah.
Mm-hmm. Thank you, Paul. So I think we're going to do our next polling question. So thanks to everybody for participating in these. The next one is, we are confident that we are ACA compliant and understand the reporting requirements for employers regarding 2015. And while people answer that question, Paul, I think this might be another good one for you since you spoke to us about the ACA and reporting requirements. Do we have to put the employer-paid benefit premiums on the employee's W-2?
Well, right now, in 2015, most employers with more than 250 employees are required to report the cost of employer-sponsored health coverage. And specifically, there's a new box 12 on the W-2 that is where you're supposed to drop in this code DD that confirms that, in fact, you are providing this type of coverage. Now, for those employers that have fewer than 250 W-2s in the prior year, or that same kind of FTE we talked about before, the value of the putting that value in the W-2 is optional right now. It is coming, however, and other benefits do have to be reported, like contributions to a health savings account. So this is why, we're saying you should be in partnership with your benefits broker to sit down and say, okay, here's our head count, here's how many W-2s we had last year, here's the reporting requirements we think we understand, and make sure that you got your payroll, benefits, HR people all in that room with a benefits provider so that your employee benefits, your reporting systems, and the structure of your plans all kind of mesh together in sort of a Venn diagram scenario so you know that you're compliant in all these particular areas. And that brings up another point, Amy, that I just want to put in there, that we have noticed that where there is not a Venn diagram, in other words, there's not good overlapping communication between payroll, HR, and benefits, problems start to happen. And one hand doesn't know what the other hand's doing. So this Affordable Care Act question is a perfect example where you should have all the key players responsible for those functional areas in the room as you're double-checking your policies with your benefits broker.
It's also probably not a bad time to start
That's
acquiring.
a great point.
Okay. How'd our poll look?
So it looks like 57% of people are confident that they are in compliance with the Affordable Care Act and understand the reporting requirements for 2015. About 43% are not sure yet or definitely don't feel that they are ready for it.
Well, to those who are not yet ready, I would say unfortunately, there is a series of penalties which could apply under the ACA. Some of them $100 a day per violation, that would be per employee per violation, and they're really going to kind of sting. Whether that gets discovered by the IRS in an audit or the Department of Labor, once it's there, it's there. So I would really encourage those people who didn't answer yes to sort of make an appointment with their benefits broker, and so we're saying contact us if you want a referral, but really kind of get on this thing because it does have teeth.
Yeah, there's one more point I wanted to make that came to mind when you asked the question regarding whether employers need to report the value of the benefits on the W-2. This is also a good time to check with your payroll provider. The larger payroll providers know this, and they're already making changes to their systems and the W-2 formats and templates that they're using. But just double check. There are some smaller payroll providers that may be behind the curve, and you don't want to be caught up in that.
Right, that's a great point. So next we're going to hear from Saul and about the new California discrimination and then smoking and cell phones.
Thank you very much. Let's go on to the section 4, new California discrimination protection slide, please. As Paul mentioned, the California legislature has actually been very, very busy introducing a number of laws, and I'm going to talk a little bit about some discrimination protections here. We're starting with AB 2751, which essentially modifies California anti-retaliation protections. So what this is essentially, is it makes it an organization, it makes it illegal, and it makes it unfair for an organization to request more or different documents for the I-9 processes. So we all know what the I-9 process is, and if we deviate from that, it is now sort of considered unfair or illegal. Also makes it unfair to refuse to honor documents that appear genuine. So be careful about that. It makes it unfair to use E-Verify in a manner that's not required or authorized. So if you have an employee and you have a disagreement with an employee, an employer who threatens to run their Social Security number through the E-Verify system after they've already verified it in the employment process is considered illegal and unfair. Similarly, it's now illegal to threaten an employee to report an employee to immigration authorities. So keep that in mind. AB 1443 essentially extends the existing harassment and discrimination protections under FEHA to a class of employees that weren't explicit in the statute in the past, but I think most employers would just naturally included them. But this makes it very, very explicit. It now includes unpaid interns, volunteers, and apprenticeship trainees. Moving right along to AB 2053, and this is one that will require some changes to your harassment prevention training. So if you provided harassment prevention training for supervisors, especially if you fall under AB 1825 guidelines, you need to be aware that the content of your training needs to be adjusted to include what's defined as abusive conduct. Okay, and abusive conduct is defined as conduct that an employer or employee in the workplace with malice that a reasonable person would find hostile or offensive. The statute, frankly, isn't really all the statute says is that your training for AB 1825 needs to include training on abusive behavior, but it doesn't expand beyond that. So it's leaving a lot of us to wonder how far that training needs to go or what exactly needs to be included. So I think consult an advisor if you wonder whether the training, if you do it in-house, actually contains the necessary language for you to be in compliance. But look out for that this year. Next slide, please. The other new discrimination protection statute that came down the legislature is AB 60. This essentially requires the Department of Motor Vehicles to issue an original driver's license to an applicant who was unable to submit satisfactory proof of legal residence in the U.S. Now, it's something to keep in mind that up until 1994, all immigrants, regardless of legal status, were able to file for a permit to drive a vehicle in California. In 1994, that was taken away, and it's created some problems. Mainly undocumented employees were required to drive without a license, and that's created other problems in our society. Well, that's led to an amendment to those rules in the form of AB 60, and in 2013, the legislator declared that as of January 1, the DMV is to issue any California residents, as long as they're able to pass the driving test, a permit to drive. Now, keep in mind that this special license is going to have a delineator. A very special note here that says federal, boy, actually I can't read it. For federal purpose.
Yeah, federal purpose apply.
Our monitor is a little far from our seating area here. Federal purpose applies. So what is that? What that means is that although they have the right to drive, that document in and of itself cannot be used, say, for example, as proof of right to work for I-9 purposes. It also limits the bearer of this driver's license from entering certain federally protected areas. So
let me clarify a little bit of that, so if I could. So
yeah.
we had a client in our agricultural area with several employees that ran out and got these AB 60 licenses. And the good news was that their insurance company now recognized them as having a valid California license, so they were able to operate company vehicles where in the past they didn't have a valid license and they couldn't. So it actually saved them a head count. That was kind of the good news. The other thing we found out in working with this was that because somebody shows you one of these special licenses, you know that they're not documented in California. But the law specifically says simply by showing you that license, you cannot consider that as evidence for I-9 purposes that they're unlawfully, here and therefore unable to work. In fact, there are limited purposes where you can actually use this license to verify address and residency. So if you have these things come up, there's some really good guidance on that, and you can contact us and we'll send it to the guidance.
Yeah, that's a good point. And keep in mind, it is not considered proof of right to work in California. So look out for these licenses as they come out. And remember, California also issued AB 2751, which does provide certain protections for immigrants. So keep that in mind. Next slide. The final area that I'll talk to you today about is around smoking legislation and cell phones. You're probably aware that e-cigarettes, there's legislation coming down the pike here that puts e-cigarettes in the same category as regular cigarettes. So bear in mind that there will probably be a requirement to change postings, and e-cigarettes should be included. And probably more importantly, and I'll spend a little bit more time talking about some of the cell phone changes, because cell phones are as ubiquitous now and as important almost as issuing an employee a phone on their desk. After July 1, every smartphone in California is going to include a kill switch. Now, while this is good news for employers who might want to be able to protect confidential information that might be in those cell phones, it does raise an issue for employers when an employee is using that cell phone for both personal and business purposes. So while that functionality is there, you need to review your current cell phone policies to ensure that you're not infringing on your employers and wiping out their data on their personal cell phones, even though there may be data on the phones that are employee data, and you want to protect for confidentiality. So that's one part of it, is the ability to kill the kill switch, basically to wipe a phone remotely. Related to that, recently there was a court, actually August 2014, where the appellate court ruled that employers must reimburse employees a reasonable percentage of their bills when they're required to use their personal cell phones for work. And to incur a liability, the threshold to incur a liability is they simply need to show that the phone was required. They were required to use their personal phone for business use. Now, I don't know about you, but I find it very hard to split the two. My cell phone is my only cell phone, and I'm conducting both business and personal use on this cell phone, and everyone has a cell phone these days. So there are a couple of options for mitigating this issue. One, of course, in the next slide, you can reimburse employees for the portion of their cell phone that they use for business use. The challenge there, of course, is that calculating what percentage of their monthly cell phone can be attributed to personal use versus business use can be rather taxing. Another option, of course, can be to just offer an employee a lump sum payment. But the challenge there is that if on a given month, if you decide, for example, to pay 50% of a fixed cost, but the employee is actually using their phone 70% for business use and 25% for personal use, then you have to have a way to adjust that cost when you exceed that amount. So it also makes it kind of administratively burdensome, but that is an option. Another option, of course, is simply purchase phones and plans for your employees. This is, although it may seem like a costly option, when you consider the fact that as of the middle of July, every phone is going to have a kill switch. If you issue an employee a cell phone with your own plan, you're free to wipe the data. There's no conflict there, and you don't have to worry about tracking and monitoring what percentage of the usage was personal and what percentage was not.
If I could jump in, that's provided you've written an appropriate cell phone policy
Exactly.
in your handbook that says it's the employer's cell phone, the employer's property, and do not put personal information on there.
Right.
And if you want personal, then you carry 2 phones.
Right.
That's what you ought to do to protect yourself if you decide to go this route. And many of our clients are picking option 3.
Right.
For this very reason.
Right. So yeah, exactly. And what we're seeing is to completely avoid the question of what is reasonable, employers are largely moving to issuing a company cell phone to their employees. I think it gives employers more control, and it's just probably easier to administer. But the message here is check your cell phone policy and write one accordingly.
Great, thank you. So we have our final participant polling question for the day. It is, we have a good system for monitoring HR compliance and updating our policies, especially relevant when we see that just about every year there are new things that we need to be in compliance with. So how frequently do most employers update their employee handbooks?
Well, I would say probably not frequently enough. We service a lot of clients, and it's not unusual for us. To go into, say, an employer to conduct an HR assessment or HR audit, which we do many of, and see handbooks that are 3-4 years out of date. It's unfortunately it's time-consuming process. It's a little technical. You have to understand kind of where, especially if you have multiple locations. It is more and more prevalent that municipalities are adopting their own laws for minimum wage, for sick leave accruals, et cetera, as we've already been talking about. So as it gets more and more complicated, I see it being more and more of a problem, but not often enough would be my response.
Let me just add to that if I could. So, and that is that, even if you do update your handbook, let's say once a year like we recommend and we do on our platform, it should be noted that that's simply one link. I mean, maybe it's a central link, but it's one link in the chain that forms the employment relationship. So if you're only looking at the handbook and you never look at your employment application, your arbitration agreement, your confidentiality agreement, your offer letter, the way you handle leaves. If you don't look at any of those other links in the chain, there could be other wide gaps in your compliance. So it's a challenge for particularly smaller employers who don't have somebody whose job it is to stay on top of all this stuff.
Right. Yeah. Thanks for the question.
So how did we do on that poll? So looks like we have, about 50% feel like they're on top of it, and maybe almost 30% do not feel like they're on top of it, and many don't know. So this area is sort of, I think, an area of growing complexity, and maybe the lesson out of here should be, we need to get some resources to work on this. And towards the end of the webinar, we'll talk a bit about some resources for you.
So next we're going to hear from Bruce about the NLRB.
Hello again, everybody, and thank you, Amy. The NLRB stands for the National Labor Relations Board, and the NLRB is a federal agency that's charged with conducting elections for labor union representation and investigating and remedying unfair labor practices. And the main body of law that is overseen by the NLRB is the National Labor Relations Act, or the NLRA, and specifically Section 7 of that, which gives employees the right to form, join, or assist unions to bargain effectively with their employers and engage in other concerted activities for the purpose of collective bargaining. Some of you may be thinking right about now that, well, since I'm in a non-union environment, I don't think this applies to me. Well, believe it or not, although less than 7% of the private sector employers are represented by unions, the NLRA does in fact provide protection and extends to non-union employees as well as union represented employees. So it's important to have an idea of what those protections are and to be thoughtful of those as it relates to your practices in the workplace. Next slide, please. So, protect concerted activity. On the last slide, that was part of the definition of the Section 7 of the NLRA that I mentioned. And really, what concerted activity is, it's really a group of people in concert, acting in concert with one another. So it's not just an individual, it's a group, which means two or more. And the protected aspect of that concerted activity in terms of the workplace, that really addresses wages, hours, and other forms of employment. And particularly of late, the NLRB has really been on the lookout for practices that might have a killing effect on the employee's right to that protected concerted activity. So you may be asking, or you may be thinking, so what is that chilling effect? What does that mean? In other words, what the NLRB is on the lookout for is practices by employers that would limit or to disencourage, for lack of a better term, employers to be able to act in concert with one another. And they're really specifically meaning the NLRB is really they're really targeting non-specific or overly broad policies that have that chilling effect. And some of the main culprits there are confidentiality agreements, harassment policies, arbitration agreements, and as well as solicitation, and most recently, this may be a topic that may be on many of your minds, social media and how to handle social media and how to address that in the workplace. Next slide, please. So in terms of best practices when it comes to the National Labor Relations Board, even if you don't have union employees, it's really important that you regularly review your policies and employment handbooks and consider taking a look at specific examples or having language around specific examples and disclaimers that is prohibited and which is not. So it's again, the NLRB is looking for those kind of overarching type of policies that would show that behavior. And if you're getting ready to do some discipline and some discharge, make sure that you keep in mind the NLRA and the potential for what's called an interference claim that would be considered disparate or enforcement of a policy. And then make sure you stay up to date, because it is an ever-changing environment in terms of the NLRB. It is, the governing panel is a three-person panel that's appointed by the sitting party, and there's political appointments, and it changes, and different stances can change from time to time from administration to administration. But because of that, it's important for employers to kind of make sure that they're on top of the changes in what's happening within the National Labor Relations Board. And with that, I'm going to hand it over to Paul. I know we're running a little bit short on time here. We want to make sure we get everybody out on time today.
Great. Thanks, Bruce.
Yep.
So on the next slide, we'll provide you with sort of our summary recommendations. And as Bruce mentioned, we're going to close on time. But what we recommend is that you establish a compliance monitoring and update process. And there are several tools out there to do that, that you partner with your benefits broker, and that you make sure you stay ACA compliant, that you implement a good technology system. I think we saw the sort of the tentacles of this in many of the compliance issues we brought up today, where you're going to have an increasing tracking requirement on many of these areas. Update and communicate your employee handbook. This really, we recommend it be done annually. especially in 2015. The whole purpose of this webinar is that there's a lot to change this year in your handbook. Make sure you've got all your current postings up there. There's many sources for that. And you might want to consider a compliance platform. We have one at SharedHR. The California Chamber has one. BNA has one. They're platforms where you can stay compliant and stay vigilant on this sort of thing. And then the other piece besides documentation is practices. You know, there's sort of twin elements of compliance. You got to have all your documents right because, you know, again, bad handbook language is a time bomb in there for the plaintiff's attorney. But practices are important too, in that you got to train your managers on these basics, and you have to establish some checks and balances. So if people do want help updating their handbook, SharedHR has got a campaign going right now through May to give a 10% discount to anyone who wants their handbook updated. But we'd encourage you to find some system to do this, particularly in 2015, given all these changes. So I see that we're out of time and we didn't get to answer many questions, so we will answer any questions that came in an email. And we thank you very much for attending our webinar today. Amy, did you want to say any closing remarks?
Just that, as you said, we did get a number of questions, and I do see those questions from the audience, so we'll be reaching out and answering those individually. And please contact us at Client Services at SharedHR or your SharedHR consultant if you'd like a PDF of the slides. We did record the webinar, so we'll be making that available as well. And with that, we'd just like to thank everybody for their participation today, and to our panelists who are providing such a good overview of 2015 compliance, and for all of our participants, and Ashley, who helped this morning to give us a good presentation, and we appreciate everybody's time. Thank you so much.
Thank you all very much.
Thanks, everybody.
Thank
you.